need to capture the case, but we don't seem to have it handy. So, Mr. Bock, are you ready to proceed? Yes, sir. All right.
Mr. Chief Justice, and may it please the Court. My name is Isaac Bock, and I represent the petitioner, Robert Bronner, on the Fourth Amendment issue. At this time, we respectfully request 3 minutes for rebuttal. We ask this Court to overturn the ruling of the lower court and hold that the warrantless search of Mr. Bronner's cell phone records is unreasonable under the Fourth Amendment. To this end, I submit the following 2 arguments. First, Mr. Bronner maintains an expectation of privacy in his cell site location information that society has already recognized as reasonable, which invokes the Fourth Amendment's warrant requirement. Second, the government failed that warrant requirement by ignoring a clear opportunity to obtain a warrant before their search of Mr. Bronner's records. Under the first point of argumentation, Your Honors, this court in Katz v. United States established that in order to receive Fourth Amendment protection, an individual must maintain an expectation of privacy that society is prepared to recognize as reasonable. Today, this court considers whether the warrantless...
Is this a descriptive or a prescriptive standard? In other words, are we trying to determine what society already does recognize as reasonable, or are we trying to say what society should recognize as reasonable? What are we trying to do with this?
Decide, Your Honor, what society has already recognized as reasonable, or what is
What's the standard for that? Are we opinion polls? How do we do that?
It's an objective standard. We evaluate, and in this case, we would contend that the reason society is recognized as reasonable is because they passed a law saying so. Title 47, Section 2.
Well, if that were the case, then you can pass a law that would essentially eliminate the Fourth Amendment's relevance to the law. So there has to be some limit on the use of positive law to define the scope of the Fourth Amendment, wouldn't you say?
Your Honor, we only contend that this law substantiates his objective expectation of privacy. And only in that regard does it substantiate his legitimate expectation of privacy overall. We also contend that he has a subjective expectation of privacy in this cell site location.
What does this law say?
Your Honor, this, according to, as cited in Carpenter, Title 47, Section 222 of U.S. Code guarantees Mr. Bronner the right to control the use of his CSLI data. The statute creates a duty to protect the confidentiality of information relating to Mr. Bronner and creates what are referred to as privacy requirements that limit the disclosure of his information by cellular companies. Your Honor, we would contend
Why
that
did the cell company think that this wasn't controlling? Obviously they did.
Your Honor, could you...
Obviously the cell company didn't think that that statute had that meaning in application because they turned it over. What was the basis for their action?
Your Honor, according to page 4 of the record, the basis for their action was because they were convinced that the health and safety of the community was at risk. Their actions do fly in the face of this statute, we would contend, and we would contend that it substantiates Mr. Bronner's expectation of privacy in the objective test established in this court's precedent in Katz.
But doesn't the cell company have at least an equal right to control that data? It's their data, right?
Your Honor, this court in Chapman v. United States, as well as Bunker v. North Carolina, found that whether or not as cited in Carpenter v. United States, found that if an individual can assert ownership of something if they don't legally have property rights over that specific item, and that's what we would contend exists in this case.
What did the data actually reveal?
Your Honor, as according to page 4, paragraph 1 of the record, the data reveals whether or not Mr. Bronner, or where he is in relation to 10 specific addresses within a 5-mile radius.
As I understand, there are several different Fourth Amendment events here, so which of these do you contend are problematic?
Your Honor, we would contend that the search on January 16th of 2016 violates my client's reasonable expectation of privacy. In that search specifically, they gained the location information of Mr. Bronner through CSLI, as well as the cell phone numbers of the people that he called from his phones that were used during that time period. We would contend that both the acquisition of his cell location information, as well as these records, because of the nature of these records, creates a Fourth Amendment violation.
Would this ever be legitimate if it was one cell site and there was an issue, an individual who shouldn't be approaching either a targeted community in that site or an individual as a restraining order? Can you use one cell site as opposed to 10?
Your Honor, if I understand the question.
Would that be a violation to use one cell site, only one cell site to acquire the same data?
Your Honor, this court actually established in Carpenter to answer that question. It found that in Carpenter, discovering the precise location of an individual in relation to one cell site is constitutionally problematic. It reasoned that one cell site is sufficient to pinpoint a phone's location in many cases within 50 meters. It further noted that apart from disconnecting the phone from the network, there is no way to avoid leaving behind a trail of location information.
But in this case, they weren't getting that level of data. They were only finding out, is he within 5 miles of a particular address?
Your Honor, the facts of the record on page 4, paragraph 1, which you are referencing, are rather ambiguous to that point. They state that they gained the information about where he was in relation to 5 specific addresses, and it's rather ambiguous onto the preciseness of that information. We would contend that there is good reason to believe that that information is very precise. The record indicates that Olympus Cellular believed that the health and
What's
safety...
the constitutional difference?
Your Honor, the constitutional difference is that a more precise data being acquired by the government reveals more intimate details of my client.
So he has an expectation of privacy if you know within 10 feet of where he's standing, but not if you know within 5 miles of where he's standing?
No, Your Honor, we would contend that the petitioner would ask this court to hold that he has expectations of privacy in both.
Doesn't the expectation of privacy in your location get substantially diminished once you leave the confines of your house? You know, when you're out and about on the street, police can follow you. Even in the Beaver cases in Knott's and Para, the police can track you using some assisted electronic means. Why doesn't that analysis go here?
Your Honor, because in this case, the information gathered by the government does include when Mr. Bronner was within private residences, perhaps, or even his own home. And the record indicates that it was just his data within 8 days, wherever he was within those 8 specific days. And it is likely, it's very
Well, not wherever he was vis-a-vis these 10 addresses in the 5-mile range.
Yes, Your Honor. Yes, Your Honor. And it's very reasonable to believe that he was within private confines during that specific time. But further, under the second point of argumentation, this court has consistently found that in order to a search to be constitutionally permissible, if it is unreasonable, there must be a warrant based upon probable cause. This court found in Mincy versus Arizona, as cited in Kentucky versus King, that warrantless searches are presumptively unreasonable. In the case at bar, the government claims that exigent circumstances justified their warrantless invasion of Mr. Bronner's constitutionally protected privacy. This court in Michigan versus Tyler, as cited in Missouri versus...
Why isn't there exigent circumstances?
Yes, Your Honor, because of this court's decision in Michigan versus Tyler, they set up a test, which we would contend the government fails.
Tell us exactly how.
Yes, Your Honor. In Michigan versus Tyler, the court found that in order for exigent circumstances to exist, there must be a compelling need for official action, and 2, there must be no time to secure a warrant. In Kentucky versus Keene, this court further held that to fit within this exception, police action literally must be taken now or never. The government fails this standard completely. According to page 5, paragraph 1 of the record, the Super Bowl and the arrest of Mr. Bronner occurred 23 and 25 days after the government's warrantless search of 8 days of his cell site location information.
What's the date of his arrest got to do with anything? It's the date of the search and what they knew at the time of the search.
Yes, Your Honor, and the respondent perhaps could contend that Mr. Bronner was the exigency, perhaps, or the Super Bowl was the exigency.
Well, I would think it's the Super Bowl because he's got human trafficking going on at a high time. And that's, I assume, what the exigency is. What did the lower court say about this issue?
But, Your Honor, in this case about the exigency,
Mm-hmm.
The lower court found that it was, I believe, the Super Bowl as well as the prize fight in Las Vegas, which again would have been 3 weeks after the Super Bowl, even demonstrating further that the exigency was far off in the future. This court found further in Missouri versus McNeely that police officers can get warrants as little as 15 minutes. There's no reason to believe in the facts of the record that the government was unable to get a warrant in such a large amount of time that spans longer than a month if we include the prize fight in Las Vegas.
Counsel, why should this court not look at a guy that potentially has, or we know has, child pornography and very graphic videos in his house? Why should we not look at that as an exigent circumstance that merits immediate, decisive action on the part of the state?
Your Honor, it's because police work, inherent in police work, there always will be emergencies. The nature of police work, that their job is to counter crime, in many cases crime of that nature. But just because there is an emergency, this court has long held that is not sufficient to establish an exigent circumstance. What is most important, as this court found in Missouri versus McNeely, is the actions of the officer before the exigency. And in this case, we can see that they ignored a clear opportunity to obtain a warrant. For that reason, we ask this court to rule the search unconstitutional.
Thank you, counsel. Ms. Turner.
Mr. Chief Justice, and may it please the court. My name is Hope Turner, and I will address the issue of the Sixth Amendment. We ask this court to overturn the decision of the lower court and hold that the admission of Andy Somerville's statements at Mr. Bronner's trial violated Mr. Bronner's Sixth Amendment rights. We ask for this ruling for the following two reasons. First, Andy Somerville's statements were testimonial because they were made to establish past events and there was no ongoing emergency. Second, because his statements were testimonial, they are then applied to the Sixth Amendment's provisions of oath, observation, and cross-examination, all of which were denied Mr. Bronner as a defendant. To the first issue, this court held in Crawford versus Washington that only testimonial statements cause a declarant to be a witness within the meaning of the Sixth Amendment. In determining then whether statements are testimonial, this court held in Davis versus Washington that the primary purpose of the statements is to be considered, specifically noting two factors. That testimonial statements are, one, made to establish past events, and two, they are made without the presence of an ongoing emergency. As the record notes in page 5, paragraph 4, and page 6, paragraph 1, Andy Somerville came to Officer Rail and told him in detail about the events that he had witnessed, specifically the video he had seen a few nights prior. Officer Rail is a school resource officer, meaning that he is a sworn law enforcement officer. At this time, Officer Rail listened to Andy's statements.
How was he dressed at the time that Andy gave him the information?
On the day in question, on Thursday, he was wearing what they call a soft uniform.
Okay.
And then the day prior, he was wearing his official police uniform.
So did Andy know he was a policeman?
Your Honor, Officer Rail notes on page 6 of the record that Andy probably knows he's a police officer, at least on the days that he wears his
So we
official
don't have any
uniform.
direct evidence of that one yet?
I'm sorry, Your Honor.
We don't have any direct evidence from Andy's mouth?
No, Your Honor, we do not have direct statements of Andy understanding that Officer Rail is a police officer. However, the record does note on page 5, paragraph 4, that Officer Rail and Andy have had interactions in the past. In fact, even just the day prior to this conversation, on Wednesday, February 10th, Andy was approached by Officer Rail, who was wearing his official police uniform, and Officer Rail asked him if he was all right. At the time, Andy replied that he was fine, but then the next day, he came into Officer Rail's office to tell him about the events that he had witnessed.
Doesn't the child's prior relationship with the officer cut against you? Because it indicates, the record indicates they had a friendly relationship. And so doesn't that indicate that Andy was maybe coming in to talk to Officer Rail because he wanted some sort of emotional counseling or support, rather than coming in because he wanted to report him in a law enforcement capacity?
Your Honor, the record doesn't specifically note what Andy believed the relationship between himself and Officer Rail to be. However, as he did know that Officer Rail was a police officer, and even just the day before Officer Rail approached him in his official police uniform, this would point to what this court noted in Ohio versus Clark to be a presumptively testimonial statement. Because in Ohio versus Clark, this court held that statements made to police officers are presumptively testimonial. Which would then bring us to
Does
the
it matter
second.
whether or not those statements are given to the police officer when the officer is acting in an official law enforcement capacity?
Your Honor, that is an important distinction to make.
So
That-
if let's say the declarant here gives a statement to a police officer when the police officer is in casual clothing sitting in a diner on their day off, does that still count?
Yes, Your Honor, the important distinction is whether or not the officer is acting in his official capacity. Specifically, if he is off duty, if he is in that situation not a police officer, then the statements would be presumptively not testimonial.
And in
Well,
this case,
Sorry, counsel, who do we look at to figure out if he is or is not a police officer acting as a police officer? Is it his thoughts, or is it the individual giving testimony's thoughts?
In regards, Your Honor, to whether or not he was acting in his official duty as a police officer, that would be in regards to Officer Rail's mindset of whether or not he was performing his job as a school resource officer at the time.
But if we care about the intent of the debt, why do we examine the mindset of the officer, the interviewer? Doesn't it make more sense to examine the mindset of the debt, not the interviewee?
Yes, Your Honor, this court held in Davis versus Washington, and according to that very question, they shifted the mindset from the from the declarant to the officer, to the person taking the statement, to determine whether or not the statements were testimonial. And in order to determine
What were
whether
the facts in
statements...
Davis that were pertinent to that?
Your Honor, in Davis versus Washington, there was a 911 call being made at the time of a case of domestic violence. And they considered in that case, this court, whether or not the 911 operator, although not a sworn police officer, was acting in the role of a police officer, which they held that the 911 operator was.
But part of the testimony was, if I understand it, in Davis, was admitted.
Yes,
And
Your
part
Honor.
was excluded.
Yes, Your Honor. And that brings us to the second prong of the test in Davis, is whether or not the statements were made in the presence of an ongoing emergency. As in Davis, there was a 911 call that was reporting facts happening just immediately prior. This court held that the statements were made to address an ongoing emergency, and the 911 operator was answering those statements to determine the safety of the declarant in that case. However, in this case, there was no ongoing emergency for several reasons. The first is that Mr. Bronner had already been arrested 2 days prior, on February 9th, 2016. But then it was on February 11th that Andy came into Officer Rail's office to give him this testimony.
Counsel, couldn't I argue that it's an ongoing emergency if, let's say, the pornographic material in question is still at the house, and Andy Somerville is continuing to go home and maybe seeing this in the house? What if this court decided to argue that that represents an ongoing emergency, that they needed to immediately address that situation? What would you say?
Your Honor, in that case, it would then hinge on the actions of Officer Rail to determine whether or not that was a legitimate threat. If in those situations, Your Honor, Officer Rail would have called the police, reported the situation, and police officers obtained a warrant and searched Mr. Bronner's home to look for that material, then that would be an instance in which this court could rule.
Does the record tell us who Andy was living with? Who was the adult taking care of him?
Andy's mother, Your Honor.
Okay, and she had been associated with and allowing a child pornographer to live in the home, right?
Yes, Your Honor.
And arguably allowed him to rape her daughter.
Your Honor, the record doesn't...
Or somebody raped her daughter, and he filmed it or something, had the film, right?
Your Honor, the record doesn't indicate whether Andy's mother was aware of these facts going
Okay,
on.
but on the basis of that, couldn't that be an emergency? That, this person is in the custody of somebody who's been so negligent as to allow all this to go on?
It could be, Your Honor. And if this
So why
court...
isn't that an emergency? That would justify this?
Your Honor, it would again hinge on the state of mind of Officer Rail. As this court held in Ohio versus Clark, a teacher who was asking questions of a 3-year-old and determining whether or not it was safe to release the child back into their parents' care, that constituted an ongoing emergency, as would be analogous to the facts Your Honor presented. However, in this case, Officer Rail did not make any actions attempting to keep Andy at school, attempting to prevent his mother from taking him back to his house.
So, counsel, what if Officer Rail is just being too lazy about this, but there's still an emergency? I mean, why is it that if, for example, you have an officer who is not taking an emergency seriously enough, that we're constrained by that? Are we?
Your Honor, the specific test that this court held is not necessarily whether an emergency exists, but whether the officer taking the statement believes an emergency to exist. And the reason for that is because the statements hinge on whether or not the nature of the statements are testimonial. That is what this court is being asked to consider, whether Andy's statements were testimonial. And because they were, then do they fulfill the Sixth Amendment's requirements?
Well, it's pretty clear, relative to your second point, that the reason that he was not put in court is the state statute. Did you challenge the constitutionality of the state statute in the lower court? Is that issue preserved in the courts?
Your Honor, this is simply an as-applied challenge.
But
We're not...
Did you argue the statute was unconstitutional as applied?
Yes, Your Honor, that's correct. Your Honor, in regards to the state statute, it specifically flies in the face of the test established in the Craig case that was threefold specifically. But first and foremost, the prong was that there must be a case-specific finding in order to prohibit a child or anyone from testifying in court.
Just so I understand the contours of your argument, Would you object if the state had chosen to use some sort of video system instead to commit to the testimony of Andy? Or would you still raise a confrontation clause claim?
No, Your Honor, those statements would be admissible because the oath, observation, and cross-examination of the Sixth Amendment would still be preserved. And that's why we ask this court to overturn.
Thank you, counsel. Mr. Bainbridge.
Mr. Chief Justice, and may it please the court. My name is David Bainbridge, and I rise to represent respondent on the Fourth Amendment issue. We ask that this court uphold the decision of the State Supreme Court of Olympus and find that Bobby Bronner's Fourth Amendment rights were not violated by the actions of the police in this case. To this point, we offer two main arguments. First of all, any cell phone numbers that were gathered by the police on the search that was conducted on January 16th fall under the third-party doctrine as established in Smith v. Maryland. Secondly, Carpenter v. United States does not apply to the type of information gathered in this case, as it was not specific and not real-time. To the first point, this court in Smith v. Maryland, as well as Miller v. United States, and corroborated in Carpenter v. United States, established the third-party doctrine. The third-party doctrine specific to Smith establishes that any phone numbers that the police gather in a real-time format, individuals do not have a reasonable expectation of privacy to those phone numbers.
The third-party doctrine goes a lot further than that. It says that anything that you pass along to some third party would reduce or potentially eliminate the expectation of privacy. And I guess I'm troubled by its application to our modern society, where we are increasingly doing just that. We use cloud-based services to store our documents or to back up our computers. We share all sorts of information in ways that wouldn't have been shared in times back during Smith or other cases when we first came up with the third-party doctrine. Perhaps we should revisit it? What do you think?
No, Your Honor. Carpenter versus United States, decided by this court just last year, affirmed the decisions in Smith and Miller in saying that individuals do not have a reasonable expectation of privacy, specifically to phone numbers that are turned over. The court in Carpenter
This was more than phone numbers. This is location data.
That's correct, Your Honor, and it's our argument not that the third-party doctrine should apply necessarily to the specific location information, merely to the phone numbers, which my opposing counsel did have an issue with.
So then what justifies your collection of that location data?
Your Honor, the collection of location data, it's our argument, falls under the precedent of this court in United States v. Jones, United States v. Knotts, and somewhat in Florida v. Riley. The reason that Carpenter specifically does not apply to this case is because Carpenter dealt with cell site location information as it applied to a continual and recorded tracking of someone's location. In this case, we do not deal with a recorded and automatic tracking of Bronner's location.
What's the constitutional difference between sporadic tracking and constant tracking?
Your Honor, the constitutional difference, as the court distinguished in Carpenter, is that individuals have a reasonable expectation of privacy, as built with the Katz formulation, in their movements at all time and in their locations. However,
so how sporadic does it have to be to invoke the Fourth Amendment? Is it if they get 99% of the time, the police are okay? Or, where's the line? How do we figure that out?
Your Honor, a potential line that could be drawn between Carpenter in this case is that when the police gather real-time evidence that's not specifically, the search is not specifically made in order to garner his location, rather used as a filter in order to obtain phone numbers, as we see in this case, then the individual does not have a reasonable expectation of privacy towards that information. But no matter
How do you
what...
respond to Petitioner's argument, though, that there is in fact an expectation of privacy in all of this data, regardless of whether it's historical or real-time, as articulated by the fact that it's now built into the U.S. Code?
Your Honor, if there is an amount of information that's gathered that is CSLI that deals with his specific recorded location, there may not be any effective difference between real-time and historical data, in that it is a compilation of his record at all times, his specific and precise location and where he goes, whether he's within his home or not.
So, counsel, I just want to make sure I understand. Are you saying it's okay for police to collect real-time data and then presumably store it as part of an investigation, but not to have not done that and then go to the cell company and ask for the same stored records.
Your Honor, to answer Your Honor's question, the potential rule that I proposed was that the police may obtain real-time data insofar as that it is not built to obtain the individual's location. In this case, as we see on page 4, paragraph 1, the police were not obtaining Bronner's location. Rather, they were using his general location within a 78.5 square mile area in order to filter relevant phone numbers. The police...
Counsel, I don't think you've answered my Associate Justice's question about the expectation of privacy being answered by, or being settled by the statute. Why doesn't the statute settle the fact it's his data, he controls it, the phone company can't turn it over as their data?
Because specifically, Your Honor, this statute was mentioned in Section 222 of 47 of the Historic Communications Act. It was mentioned in Justice Gorsuch's dissent in Carpenter. However, we see in Justice Kennedy's dissent in Carpenter, which was concurred with by Justices Alito and Thomas, that the statute doesn't even indicate whether the possessory interest and the privacy interest in that information belongs to the company or to the individual. In Carpenter and in the statute establishes that the individual has no control over whether that information is used, and that there are several exceptions in which the company is able to disclose.
What if I store my diary instead of in physical book on my computer? I use a backup service like Carbonite or something, so that way if my computer crashes, I don't lose all my documents. Whose data is that?
Your Honor, if Your Honor has not established that diary with a third party, the documents are certainly yours.
So then what if I use a cloud-based service like Google Drive or OneDrive, Microsoft, something like that, where it's stored by another company? Whose documents are those?
Your Honor, the record is rather unclear as to cloud-based distinctions. However,
of course, but I'm asking what your reasoned position would be. Whose documents are those? Are those my documents? Are those Microsoft's or Google's documents? Whose are they?
Your Honor, it's respondent's position that those would most likely be your documents and you'd have a reasonable expectation of privacy in them.
What's the difference?
Because
one's electronic storage, the other's electronic storage. What's the difference?
the reason there's a difference, Your Honor, is because as the court made the distinction in Carpenter, the reason individuals would have a reasonable expectation of privacy over such information as diaries and over such information as their specific location as it's compiled in a record is that it is specific and invasive of their reasonable expectation of privacy.
Seems pretty darn invasive to know where I've been all the time.
So,
In fact, probably even more invasive than knowing what I've written down in my diary.
Certainly, Your Honor, and that's the distinction that this court made in Carpenter. However, in this case, the police have no indication as to Bronner's location within 78.5 square miles.
But do you know where he is? They used this location information.
Your Honor, they use this location information not in order to locate him, but in order to filter through and find the relevant numbers.
So they used this information to find other evidence, right?
They use this information in order to filter their search for phone numbers, Your Honor.
True enough, but they could have been using the information to find where the knife is buried, or use the information to find where the murder victim is. You can use it for a lot of things. The question is, what information are they using? And it's his location, right?
Your Honor, it's his location insofar as it is a binary yes or no indicator as to
So
whether he...
what, if they used his location information and searched for anything besides phone numbers, would you agree that the use of the location information violates the Fourth Amendment?
Your Honor, it would have to depend specifically on what type of information was being gained. If they were trying to obtain his location or his house or what he was doing within his home, certainly there would be Fourth Amendment protections. But if they're simply trying to obtain his phone numbers, the record of his phone numbers, or for example, his bank records, as the United States v. Miller has established, there is no reasonable expectation of privacy to that type of information under the third-party doctrine. And when this court has dealt with real-time surveillance in the past, it has dealt in cases such as United States.
The third-party doctrine has always been on the information in question. And you're saying, don't look at the information in question, look at what the information in question leads to. Where have we ever used that? I mean, you seem a little bit uncertain about the location information itself being within the government's ability to reach. So I don't get it. Is the location information always good or not always good? Because I don't think you have it both ways.
Your Honor, I believe that the distinction is made in this court's decisions in such cases as United States v. Knotts, as cited in footnote 10 of Justice Alito's concurrence in Jones, and such cases as Florida v. Riley, as cited in Justice Gorsuch's dissent in Carpenter. In Knotts, this court held that when an individual is traveling on public thoroughfares, he has no reasonable expectation of privacy to his location on those public thoroughfares. And
But if you track somebody forever and ever, that's different, right? Through electronics, because there's just not enough police to go around to track somebody everywhere. And you cross the line at some point in time. Electronics allow you to do stuff that you really couldn't do with live officers, right?
That's correct,
It
Your Honor.
allows the police to have essentially unlimited resources. They don't have to spend money on officers or spend officers' time on tracking suspects. They can simply do it through an automated system. Isn't that precisely the sort of problem that the Fourth Amendment's requirement is designed to prevent?
Yes, Your Honor, and Knotts ruled that if there was a tracker placed, on a chloroform bottle that Knotts specifically had in his vehicle, and that vehicle was tracked, and the court ruled that since it was
He was not just being tracked, he was actually actively being followed by agents trying to follow his car.
That's correct.
This was just the use of some electronic aid to surveillance. This wasn't an automated system or something where police officers could monitor multiple people at the same time.
That's correct, Your Honor, but as footnote 10 of Justice Alito's concurrence in Jones points out, the police did lose the signal on multiple occasions of that tracker, and they had to rely solely on the tracker in order to determine where he was.
Do you think the Communist Party is tracking the cell phone locations of the protesters in Hong Kong?
I can't be sure, Your Honor.
Wouldn't you? Let's assume that they are.
Yes, Your
Do you
Honor.
think that violates their expectation of privacy? Do they hope that the commies don't know where they are?
Your Honor, I see that my
Do you have time to answer?
Your Honor, yes, if the Communist Party is specifically tracking the cell phones of the people in Hong Kong, then there is a violation of their reasonable expectation
What's
of
the
privacy.
difference?
The difference is
Aren't
that,
we becoming like communist China?
Your Honor, the difference is that in that case, and in such cases as Carpenter, there is a detailed tracking of their location in order to determine where they have been. In this case, there is no tracking of such location, rather a filter by which they would obtain relevant cell phone numbers. And it's for those reasons that we ask that this court uphold the decision of the Olympus Supreme Court and find that Bobby Bronner's Fourth Amendment rights were not violated. Thank you.
Thank you, Counsel. Mr. Anderson.
Yes, sir. Mr. Chief Justice, and may it please the court. My name is Riley Anderson, and I rise to represent the respondent on the Sixth Amendment issue. The statements regarding Bobby Bronner's possession of child pornography did not violate the Sixth Amendment. Under the case law of Crawford versus Washington, the court found that statements that are testimonial implicate the confrontational clause, but statements that are non-testimonial do not implicate the confrontation clause. In this case, the statements were non-testimonial, and therefore the Sixth Amendment was not violated. In determining whether statements were testimonial, the court laid out the primary purpose test under Davis versus Washington. This test first examines whether the statements are given to police officers, and then examines whether or not the statements are going to meet an ongoing emergency or to establish past events. First, with regards to whether Officer Al was acting as a police officer. Here, Officer Al was not acting as a police officer, as evidenced by Andy Somerville's mindset towards Officer Al and Officer Al's actions. When first looking at Andy Somerville's mindset, he's had previous experiences with Officer Al as per page 5, paragraph 3 of the record.
Isn't there just something so transformative about a citizen